Today, we're diving into a major development in Colorado housing law, Senate Bill 20. This legislation introduces a new receivership process to address neglected multifamily properties across the state. You've all seen those properties with overgrown grass, weeds in the yard, couches out front, etc. The purpose of Senate Bill 20 is clear: to ensure a safe, habitable living conditions for tenants in Colorado. So it does this by establishing a legal pathway for applying and appointing third-party receivers to manage properties that have fallen into serious neglect. The law also outlines the rights and responsibilities of both landlords and tenants under this new framework. So, when does receivership kick in? It's triggered by specific patterns of neglect. Think vermin infestations, broken locks, and other safety hazards. And who can request it? The Attorney General, counties, cities, and municipalities all have the authority to initiate receivership when public safety is at risk. The goal? To repair neglected properties and give tenants a clear path to safer living conditions. So once appointed, the receiver takes over property operations. That includes rent collection, financial management, and critical repairs. They're also required to maintain regular communication with tenants. But here's the key point. Landlords still retain legal and financial responsibility for the property. So receivership lasts a minimum of 90 days and only ends when the landlord proves they can maintain the property responsibly. So why does this law matter? Because it targets severe property neglect that threatens tenant safety and community standards. It empowers officials with a clear legal tool to act against neglect and landlords who are negligent. And it enhances tenant protections by strengthening enforcement and promoting accountability. So let's talk about impact. Landlords are now expected to proactively maintain their properties to meet housing standards. Tenants, on the other hand, gain new mechanisms to address unsafe conditions. Receivership ensures repairs and communication. So, as we move forward, it is vital for all stakeholders to understand what Senate Bill 20 does before it takes effect. Landlords should review their property management practices. Tenants should familiarize themselves with their rights. The receivership process marks a shift toward greater transparency, accountability, and tenant safety. So to stay informed, be sure to subscribe and enable notifications for updates on Colorado's evolving real estate laws.